So today's topic of Section 9 and 11 cases, you are welcome. And today, of course, our presenter is Jasveen Bindra. And we have our on panel, Ms. Kalpana Purohit. And Ms. Kalpana is a MSc Computer Science, MBA Banking and Finance, CIB from IIBBF, Resolution of Stress Asset with special emphasis on IBC 2016 from IIBF. He is the Chief Manager, Indian Bank Mumbai, and having extensive experience in banking retail customer service, recovery stress asset, SARFAESI, IBC code, and she has skills in corporate banking, retail banking, recovery of stress asset. Welcome, ma'am. Thanks a lot for your time, and we'll look to see and listen from you and learn from your experience. Thanks a lot. Thank you. I request Ms. Kalpana to say a few words on the topic, and if Mr. Atul Mehta has to say some few words, and then Jaswin can start the session. Thank you.
Yeah, Dipti, we are very lucky to have, Kalpana ji. She's from the other side of the chair, banker side. And probably, she must have handled more than 100 cases of insolvency professional. And I had an opportunity to interact, in one of the cases. So, yeah. So, lucky to have you, madam. We can see from the other side, other angle, how the bankers, looks this IBC sections and all process. So, and we also have our other partners, Devang Thakkar. Devang, welcome you. And yeah, we have so many other seniors, which is part of this. Sanjay also is a good friend of mine. Yes, Sanjay Sringarpure. Good to see you in this learning stage. Yeah. Yeah. So, Kalpana ji, you wanted to say something? Then probably we can ask Jasween to start with.
Sir, I'll be speaking a bit later because one urgent meeting is going on.
Oh, so, okay, no problem. So we can ask.
No problem. Thanks a lot for your devotion. Thank you. Thank you. Yeah, Jasween, you can start.
Yes, I'll just start with my presentation. Good evening to one and all present here. It is always a pleasure to have you all here discussing on new topics and understanding the views. And it is my privilege to be the presenter for today. So today we are talking about application process under Section 9 of the Insolvency and Bankruptcy Code and the relevant case laws, the main case laws covering this so that we can understand the interpretation of these sections better. So Section 9 of the IBC deals with initiation of corporate insolvency resolution process by operational creditors. So to understand this, it is first important to understand what is operational debt as defined under Section 5, subsection 21 of the IBC. Operational debt means claim in respect of provision of goods or a claim in respect of provision of services. And they have also specifically included any claim pursuant to employment or a debt in respect of payment of dues arising under any law and payable to the central government, state government, or local authority, which means per se, the government dues are specifically included under operational debt. Certain important case laws which help interpreting this definition of operational debt better are Autocast Retired Employees Welfare versus Autocast Limited. It is an NCLT Kochi bench decision wherein it was stated that the service of workmen is considered to be operational debt, but any welfare claim in respect of leave encashment or superannuation dues would not be considered to form a part of the operational debt. So therefore, a clear distinction between service claims of the workmen versus welfare claims had been drawn pursuant to this judgment. The second judgment is Jaipur Trade Expo Center Private Limited versus Metrojet Airways Training Private Limited. This is an NCLAT judgment wherein it was stated that if a licensor claims payment of license fees for pursuant to the use of premises for business purpose, this shall be covered under the ambit of operational debt. So always the question of license fees for use of premises and rent has been debated multiple times before several forums. However, this judgment kind of settled the dust for the license fee payment with regard to use of premises.
You rightly mentioned, Jasveen, earlier it was very clear that rent is not a part of operational cater, but this judgment made it clear very much.
Absolutely, absolutely, ma'am. Then the very celebrated case law and quite a recent one was a Consolidated Construction Consortium Limited versus Hitro Energy Solutions Private Limited. So under this judgment, the Supreme Court had held that any advance payment made to the corporate debtor, and if that advance relates to supply of goods or services, would be considered as operational debt. Prior to this judgment, any advance payment was not per se considered as a part of operational debt, but the situations changed drastically after this Supreme Court judgment. Then came in Minions Venture Private Limited versus TDT Copper Limited, wherein it was stated that the discounting of invoices would also be considered as operational debt, and the financer who discounts the invoices will step into the shoes of the operational creditor. So even if the discounting work is done by any financial institution, but since the debt arises due to the discounting of an operational debt, this per se would be considered as an operational debt itself.
This is something unique, when you are so you are getting into the shoes of the
yes, the financer who has discounted the bills will come into the shoes of the operational creditor whose bills has been discounted by it. Moving ahead, Trafigura India Private Limited versus TDT Copper Limited. It is an NCLAT judgment wherein it was held that in case of a default of installment pursuant to a settlement agreement, then such a amount or such a default would not be considered as an operational debt. This had created a lot of havoc because there were several settlement agreements entered into and cases withdrawn on the basis of this settlement agreement. However, this judgment came in to say that any default in installment of the pursuant to the settlement agreement would not be treated as operational debt. And therefore, after this, the operational creditors became even more mindful while withdrawing the petition on the basis of settlement. Night Riders Private Limited versus Global Fragrances Private Limited, an NCLT judgment wherein it was held that wherein a guaranteed minimum royalty.
Jasveen, honestly speaking, this is really complicated what you said just now. That one operational creditor settle and there is a default, then they do not remain operational creditor, right?
Yes, if they're claiming it on the basis of the settlement agreement only.
Yeah. So that means they told that you come again and file application.
Yes.
Not based on settlement breach of default. But luckily, recently only a few months back, we were able to get it from Mumbai NCLT, just for your information.
Okay.
The settlement default was there.
It is beyond the scope of this judgment then, what was held by the NCLT.
Yeah, we were able to get it. So it's really confusing. So I think there's nothing wrong in trying at least once.
Practical tip there.
Yeah.
Yeah.
Thank you.
Night Riders Private Limited versus Global Fragrances Private Limited. Under this, the NCLT had held that wherein a minimum guaranteed royalty is confirmed to be paid as a consideration for grant of license or a right to use the trademark, then that minimum royalty would be considered to be an operational debt. Which means if that royalty is not paid, the person can proceed under Section 9. BSC Limited versus KCC Plastic Limited, an NCLAT judgment, wherein they had particularly stated that statutory dues should be separated from regulatory dues. So statutory dues are per se considered as operational debt. However, listing fees, which is in the nature of regulatory dues, falls outside the ambit of operational debt. So they'd also quoted the Insolvency Law Committee, wherein the committee report specifically suggested that regulatory dues should not be covered as a part of operational debt. Therefore, the claim of BSE Limited for listing fees was rejected.
Just in 1 minute. And it was really a big judgment because Bombay Stock Exchange has filed several applications for IBC under this, and then it was stopped. So the company were relieved.
Yes, absolutely. Noida versus Anand Sonbhadra, Supreme Court judgment, again, another big judgment as regards Noida as an authority was concerned. So here the dispute was regarding whether the lease of land by Noida and the dues that arise thereto by the builders, would that be treated as operational debt or financial debt? So here the Supreme Court had clearly stated that the lease amount due from the builders that is payable to Noida would be treated as operational debt. Pursuant to the definition of operational debt arises the definition of operational creditor under section 5 subsection 20. Operational creditor is defined as a person to whom an operational debt is owed and will include any person to whom such operational debt has been legally assigned or transferred. Case studies to deliberate on the definition of operational creditor. Certain important case laws are as follows. First is Anand Natwarlal Khant versus Kush Structure Private Limited. It is an NCLAT judgment that had stated that to be an operational creditor, it is necessary to show that there is an operational debt, and such claims should be in regard to provision of goods or services only. The second judgment is of Cooperative Rabobank UA Singapore branch versus Mr. Shailendra Ajmera. This was an NCLAT judgment which held that an operational creditor who is legally assigned or transferred any of its operational debt even to a financing company, then the financing company would become an operational creditor, since an assignee or a legal transferee is covered under the ambit of operational creditor. Now, so whenever an operational debt becomes, there is a default in the payment of the operational debt, like we have seen the definition and ambit of the operational debt. In such cases, as a pre-step to filing the application under Section 9 before the NCLT for initiating CIRP, the operational creditor is first obligated to deliver a demand notice of unpaid operational debt under Form 3 or a copy of invoice demanding payment under Form 4 of the amount involved in default to the corporate debtor. This obligation is being made under Section 8 of the IBC. On the receipt of this demand notice or the invoice, the corporate debtor shall within 10 days either bring the existence of a default or a dispute, the existence of a dispute to the operational creditor, or make the payment of the unpaid operational debt if there is no dispute involved. This area of Section 8 and the service of demand notice has been highly litigated, and some of the main case laws in this respect are Nitin Singh, the proprietor of Sri Sham Printers versus Waves Biotech Private Limited. This is an NCLAT judgment wherein it was held that the receipt, not just service, but the receipt of demand notice by the corporate debtor is a very essential precondition under the IBC. Second important judgment was Indrani Saha versus BK Podder Printing Private Limited. This is an NCLT Kolkata bench judgment wherein they had said that even if the service of the demand notice is made to the email ID registered on the ROC website of the corporate debtor, that would also be deemed to be a valid service of the demand notice. Thereafter, in KB Polychem India Limited versus KG Shootech Private Limited, this is an NCLAT notice sent at the corporate debtors registered office, but if it was returned back with the remark of not, but if the notice is personally served or if a service is being made to each of the directors of the company of the corporate debtor, and such demand notice has reached the directors and has not been returned, then it would be again deemed to be a valid service. So which means even if the corporate debtor is maybe the registered office is not available, then we can also try and make a service to the directors of the corporate debtor. Then Sri D. Srinivasan Rao versus Vaishnavi Infratech Limited. This is a very popular NCLAT judgment wherein the NCLAT had held that if the demand notice was returned unserved, then that would amount to non-delivery of notice. But where the corporate debtor refused to accept the delivery of the notice, particularly, then that would not be, the adjudicating authority would not be justified in coming to the conclusion that the notice has not been served, because this can cause a lot of mischief in the end of the corporate debtor where they do not accept the notice. In the same judgment, the NCLAT had deliberated further upon the importance of the service of the demand notice, and it had stated that the delivery of demand notice is intended to put the corporate debtor on notice so that they can highlight any pre-existing dispute to the operational creditor, or in case there is no such dispute, then it is an opportunity given to the corporate debtor to clear its liability. They have said that it is now well settled that the service of this demand notice, the delivery of this demand notice under Section 8, subsection 1 is a sine qua non, which is a condition that cannot be eliminated for initiating a CIRP under Section 9 of the IBC. Moving ahead, these judgments, set of judgments deal with whether to choose Form 3 or Form 4. What decides the distinction between the service of a demand notice under Form 3 or the service of the invoice under Form 4? So in Neeraj Jain, the director of Flipkart India Private Limited versus Cloudwalker Streaming Technologies Private Limited, an NCLAT judgment, wherein it was held that the choice of issuance of demand notice in Form 3 or in Form 4 depends on the kind of or the nature of the operational debt. It is not just a discretion or on the convenience of the operational creditor. So this judgment had stated that the applicability of Form 3 or Form 4 would depend on whether the invoices were generated during the course of transaction or not. And in case the invoices were generated, then the Form 4 service would be preferable. Whereas in case the invoices are not generated, not mandatorily generated as during the transaction, then a Form 3 demand notice should be served.
This was very good clarification given by them. Earlier, it was not clear. And people used to ask, why Form 3, why Form 4, what is the difference? This is very clear, because 4 doesn't clarify this.
Right. This is the only judgment till date that gives some clarity in this regard.
Right.
However, this judgment was quite misquoted as well, and the corporate debtors used it to their advantage to save themselves from Section 9 proceedings. Therefore, the next judgment of Tudor India Private Limited versus Servotech Power Systems Limited, which was an NCLT judgment, wherein it was held that where an operational debt arises out of provision of goods and services, and where the invoices are raised, there is no per se illegality in choosing Form 3 of the demand notice service, provided that the unpaid invoices should form a part of the annexures that are annexed to Form 3. So issuance of demand notice under Form 3 annexed with invoices by the operational creditor would be considered to be in order of the rules, applicable rules.
Mixed match is allowed.
Yes, that is true. This is just because the corporate debtors were using that judgment to their advantage and misquoting it basically. So they said that is not something that is illegal. That is just a correct system of following it. Okay, the next judgment is of Kode Boyina Srinivas Krishna versus PVM Invensis Private Limited, an NCLAT judgment wherein it was stated that a demand notice in Form 3 should explicitly mention the date of default, and on the basis of the supplementary documentation and the backing documents for it, the date of default ascertainment is really important as regards a demand notice under Form 3. Then came the question several times as to who exactly can serve the demand notice, or in whose name can the demand notice can be issued. So the famous judge.
Actually, Jasveen, sorry, but this date of default actually is a very important aspect for any IBC application, because then your limitation period is very crucial for that date of default.
Right.
So one has to be very clear, because there are several cases that, in the form date of default written is different, and the document actual date of default is different, and then it is questioned. So one has to be very careful while drafting the application and ensure that date of default is correct and it's correlate with the supportings, because that will decide the validity of the claim. Thanks, please.
Yes, there have also been cases where the date of default quoted in Form 3, that is the demand notice, versus stated in the application, there was a mismatch. So even NCLT Mumbai has rejected applications on that basis and asked them to file it afresh. So the famous judgment of Macquarie Bank Limited versus Shilpi Cable Technologies Limited. This was a Supreme Court judgment, and in the initial years of IBC, since it's a 2017 judgment, as we can see. So this states that demand notice of the unpaid operational debt can be issued by the lawyer also on behalf of the operational creditor. Since at that point in time, IBC was in a very nascent stage, this question always arose whether a lawyer can make a valid, can validly issue the demand notice. So the Supreme Court settled this. Now, on the basis of this judgment, in a comparatively recent judgment by the NCLT, Mohit Minerals Limited versus Nidhi Import Trade Private Limited, here it was held that in case a person other than an advocate serves or issues the demand notice, then the board resolution should be there to support such authorization. But where an advocate duly instructed by his client, being the operational creditor, issues the demand notice, then there is no need to specifically that to be backed by a board resolution. So like it was said under Section 8, the reply to the demand notice by the corporate debtor can be in two situations. One, to highlight a pre-existing dispute, or second, if there is no dispute, then to go ahead and make the payment. The word dispute has been defined under Section 5, subsection 6 of IBC, and this becomes very integral for the purpose of filing of any application under Section 9 to ensure that there is no dispute. The definition given under IBC to the term dispute is an inclusive one, which means it has a very wide ambit. So it states that dispute includes a suit or arbitration proceedings relating to existence of the amount of debt, the quality of goods or services, or a breach of representation of warrant or warranty as regards the agreed terms. Certain case laws on the point of dispute are as follows. Mr. Chetan Sharma versus Jay Lakshmi Solvents Private Limited and another. This is an NCLAT judgment wherein it was held that dispute cannot mean any dispute. It has to be a dispute particularly between the operational creditor and a corporate debtor. In this case, the corporate debtor had taken a defense that there is an internal interstate dispute between two groups of shareholders of the corporate debtor. So the NCLAT in this case held that has nothing to do with this particular transaction between the operational creditor and the corporate debtor. So this would not be treated within the ambit of Section 5, subsection 6 as regards dispute is concerned. Next is Mr. Keshav Kantamneni, ex-managing partner of Uniply, managing director of Uniply Industries Limited versus Messrs. Kishan Chand Suresh Kumar, NCLAT judgment, wherein it was stated that to point out dispute, a mere denial or stating that no payment is due or no payment will be made, that cannot constitute dispute. To decide whether there exists a dispute or not, it has to be a concrete contention that is to be made, and that contention should be supported by evidence to the satisfaction of the adjudicating authority. Then came in Raghuveer Buildcon Private Limited versus Ketan Construction Limited, NCLT Ahmedabad judgment, wherein it was stated that a normal commercial or legal difference per se cannot be treated to be dispute unless such differences are ascertained into a claim, or both on which both the parties have different or opposite views and want to settle the same through any legal process or otherwise, maybe by way of a normal discussion as well, but there has to be a particular difference in the ascertainment as regards a claim is concerned. A routine correspondence in commercial relationship cannot automatically or necessarily be considered or admitted as a dispute unless the stage is reached wherein there is a clear different or distinguished difference in the views involved of the operational creditor and the corporate debtor. Dinesh Gupta versus Hajura Singh, Bhim Singh and another, NCLAT judgment, and this was basically where more than one demand notices were issued. So it stated that there was no dispute in the existence of the debt prior to the issuance of first demand notice under Section 8, and the corporate debtor disputed the claim about quality only after the issuance of the first demand notice. Therefore, once the application was withdrawn on technical grounds under Section 9 and a fresh demand notice is issued, the corporate debtor cannot take the contention that they had disputed it for the first time. They will have to again dispute the debt after the issuance of the fresh demand notice. Then came in Messrs. M+R Logistics India Private Limited versus AGA Publications Limited, an NCLAT judgment wherein the Honorable NCLAT held that the corporate debtor must bring to the notice of the corporate debtor the existence of the dispute or a record of pendency of any suit or arbitration proceedings before the receipt of the notice or invoice in relation to such dispute. That means after receipt of demand notice, the corporate debtor cannot wake up to say or highlight that there was a dispute and use it as a safeguard against them. There should be a pre-existing dispute. So once the demand notice has been served and a reply has been made in that regard by the corporate debtor, or where there is no reply, say by the corporate debtor, then the operational creditor can go ahead and file an application under Section 9. So it states that after the expiry of 10 days from the date of delivery of the notice or invoice demanding payment, if the operational creditor doesn't receive payment or any notice of dispute, the operational creditor may file an application before the adjudicating authority, being the Honorable NCLT, for initiating CIRP against the corporate debtor. Certain case laws in this regard, Brand Realty Services Limited versus Messrs. Sir John Bakeries India Limited. This was an NCLAT judgment wherein it was stated that if the corporate debtor does not reply to the demand notice under 8 subsection 1 of the IBC within 10 days, or if no reply has been filed by the corporate debtor, this does not preclude or basically prevent the corporate debtor to raise any further points of pre-existing dispute before the adjudicating authority. That means the corporate debtor will still be given an opportunity in case of hearings or during the pleadings to point out any pre-existing dispute. What are the documents to be filed to support the application under Section 9? A copy of the invoice demanding payment or the demand notice that was served, that is Form 3 or Form 4, as the case may be. An affidavit to the effect that there is no notice given by the corporate debtor relating to dispute of the unpaid operational debt. A copy of the certificate from the financial institutions confirming the financial institution of the operational creditor, wherein they confirm that no payment has been received by the operational creditor as regards this operational debt that is claimed, if applicable, and a copy of the record with the information utility confirming that there is no payment of unpaid operational debt, if applicable, if available, and any other proof to substantiate the claim of the operational creditor. As regards the point of issuance of affidavit stating that there is no notice of dispute received, it was held in Sangeeta Goel versus Roydek India Chemicals Private Limited, an NCLAT judgment wherein they had stated that this affidavit can be issued only in a situation where the corporate debtor within 10 days of receipt of the demand notice has not sent any reply to the operational creditor. If the person, operational creditor, has received a reply, may be substantiated or not, that is for the adjudicating authority to decide, but they cannot go ahead and file this affidavit as a part of the application then. Whether the certificate from financial institution maintaining the account of the operational creditor confirming that they have not received the amount of operational debt is mandatory. This was highly discussed before the NCLT and NCLAT, and in Smart Timing Steel Limited versus National Steel and Agro Industries Limited, the Honorable NCLAT had actually held that it is mandatory to obtain such certificate. However, pursuant to an amendment to the Insolvency and Bankruptcy Code by way of the Second Amendment Act in 2018, they had changed the statute to say that the requirement of this certificate to be issued by the financial institution would be directory in nature, with effect from 6 June 2018. So once the application has been submitted before the adjudicating authority, there are certain conditions to be satisfied to the satisfaction, of course, of the Honorable NCLT, when an application can be actually admitted by them. So for this purpose, the application should be complete, which means all the conditions as stated before, forming mandatory attachments to the application, annexures to the application must be present. There should be no payment of the unpaid operational debt. The invoice or notice for payment should be delivered, that is Form 3 or Form 4 should have actually been delivered to the corporate debtor. No notice of dispute should be received by the operational creditor in regard to this debt, and wherein the operational creditor has suggested an insolvency professional to act as the resolution professional, then no disciplinary proceedings should be pending against such insolvency professional. The most important judgments whenever a Section 9 application is concerned is that of Mobilox Innovations Private Limited versus Innoventech versus, sorry, just change this. Yes, so this judgment is a very celebrated judgment, wherein the Supreme Court for the first time had deliberated on the important aspects to be considered in case of a Section 9 application. So they had categorically stated that the adjudicating authority, while examining an application under Section 9 of the IBC, should determine on three main questions. First is whether there is an operational debt. Second, whether there is documentary evidence furnished with the application shows that the aforesaid debt is due and payable and not paid yet. And the last is whether there is existence of dispute between the parties or the record of pendency of any suit or arbitration proceedings filed before the receipt of the demand notice of the unpaid operational debt in relation to such dispute. If any one of the three conditions is lacking, the application should be rejected. These are the clear conditions that the Honorable Supreme Court had laid down for an adjudicating authority to assess a Section 9 application. Further, in Writers and Publishers Private Limited versus Oriental Code Corporation and NCLAT judgment, it was held that for a pre-existing dispute to be a ground to reject an application under Section 9 of the IBC, the dispute that is raised must be truly existing at the time of filing of the reply to the notice of demand or at the time of filing of the application. So like I stated, it should be a pre-existing dispute and it cannot be stated for the first time when the application is being considered. Mr. Kuldeep versus Future Netwing Solutions Private Limited, an NCLAT judgment wherein it was stated that under the scheme of this code, no notice of dispute has been issued and dispute raised is supported by any evidence. It cannot be taken only as a moonshine defense, and there should be a substantial dispute considering at the time of as a ground to reject the application under Section 9. Then came the judgment, quite a recent one, in Arpana Packaging Private Limited versus Regma Ceramics Private Limited. This is basically an NCLAT judgment which states an inter se between the MSME Act and the IBC, wherein it was stated that if a case is pending before the MSME Facilitation Council under the MSME Act, then that can be a sufficient proof for saying that there is a pre-existing dispute in light of the Mobilox judgment. However, a contrary view was taken by the NCLAT in iView Advisors Private Limited versus Srinagar Banihal Expressway Limited, wherein it was stated that only because the appellant went to the MSME authorities, then that cannot be a valid ground for the adjudicating authority to reject the application under Section 9. So these are two judgments with very contradictory views as regards filing of a proceeding with MSME.
So what one has to do?
Unfortunately, the more recent one says that if you're filing an application with the MSCFC, then that is a proof of dispute. So until there is something that overrules that, I think that should be the view.
Okay.
Then came in the judgment of Yogendra Yasupal versus Jigsaw Solutions and another. This is an NCLAT judgment which states that if there is a trial pending against the officer of the corporate debtor or individual proceedings against the officer by the court, then that cannot be treated to be an existence of dispute. In Gandhar Oil Refinery India Limited versus Madhukorn Sugar and Power Industries Limited, the NCLAT had held that in an application under Section 9, the question of merit of dispute cannot be decided. That means the adjudicating authority should not go into a detail as to what is the impact of the dispute or how substantial is the dispute. All they need to know is if there is prima facie in their view, there exists a dispute among the corporate debtor and the operational creditor as regards to that operational debt, then that can be a sufficient reason for the adjudicating authority to reject the application under Section 9. Then in Mohit Motawal versus Madhu Sharma, proprietor of Hind Chem Corporation and another, the NCLAT held that a CIRP application under Section 9 is not maintainable in case of the principal amount has been entirely paid and the claim is only in regards to interest. That means in this particular case, the Section 9 application was filed only on the basis of claim of interest. So the NCLAT then settled down to say that if your entire principal amount or the amount of the operational debt has been paid, you cannot come to the adjudicating authority under Section 9 only for the claim of your outstanding interest amount.
Jasveen, interesting question comes whether this interest recovery will be OC or FC if that one comes, or it will not stand at all as OC or even FC.
So, ma'am, generally what view the NCLT takes as regards Section 9 applications is there has to be specific terms agreed to as regards to interest, wherein if there are any terms agreed to between the operational creditor and corporate debtor, you have to state that if they default in making the payment, then this percentage of interest would be charged. Other than that, they don't usually accept the interest component.
I think
Okay.
same is valid for both operational as well as financial creditors. Section 7 or Section 9, both. It is valid for both.
So only interest is not the stand on which you can file the claim, right?
But
Or
if
file
there
the
is a
application.
certain terms or acceptance of the terms for the interest, then it will stand.
Okay, thank you. Jaswin, there is a question that interest amount is of 1 crore. The same thing, even though you can answer it just.
Yes, interest amount is of rupees 1 crore. Even then, if it is purely for the purpose of interest, then that case that is not maintainable, which is what this NCLAT judgment states. Can I move on, ma'am?
Yeah, please.
Yes. Then comes the point of limitation, another very important aspect to be considered. So in MCC Concrete versus Northway Spaces Limited, in this, the NCLAT had held that the period of limitation will start from the last date of payment, which is shown in the ledger account. The issue that arises with regards to limitation where an operational debt is concerned is that these are continuous series of transactions that continue. So purchase of goods or supply of services is something that happens continuously in the business. So it becomes very difficult to determine that what is the last date or from where the period of limitation should be calculated. So just to settle that, the NCLAT held that when the last payment or last transaction is shown in the ledger account, from that date onwards, the period of limitation should be counted. This is more in the recurring nature of transactions. Then in Vivek Jha versus Daimler Financial Services India Private Limited and another, and NCLAT.
This was very important judgment because the CD used to take advantage like anything. They will just say that they have paid current invoices, old invoices are outdated, and so limitation period. And this was really important judgment for the application. Thank you.
Right. Then came the judgment of Vivek Jha versus Daimler Financial Services India Private Limited and another. Under this, the NCLAT had held that if there is an acknowledgement of debt by the corporate debtor within the prescribed period, then a new limitation period will start. This is almost the same even for as regards the financial creditor application under Section 7. So an acknowledgement of debt gives a new lease for limitation. The important point that is considered after, specifically after 24th of March 2020, that is the date of notification wherein the MCA notification wherein it was stated that the limit now for filing an application under Section 7 or Section 9 would be 1 crore, enhanced from 1 lakh to 1 crore. So the question always arose during that time as to what should be the correct date for determining the date of default and from when will this be applicable. So one of the most celebrated judgments was of Jumbo Papers Products versus Hansraj Agrofresh Private Limited, wherein it was held that the threshold limit will be applicable on or after 24/3/2020, even if the debt was of an earlier date. So the application should be made on that date or thereafter. The second was the judgment of Messrs. Metracraft Private Limited versus Messrs. RM Controls Private Limited. Here the issue was the debt related to a period prior to 24/3/2020. The demand notice was also served prior to 24/3/2020, but the application was filed under Section 9 after such date. So then they stated that the threshold limit of 1 crore would be involved, would be considered for this matter, and a lower limit would not be considered. One of the most recent judgments and the question that arose was whether the interest component would also be added on to for the purpose of counting of this 1 crore limit. So in CBRE South Asia Private Limited versus United Concepts and Solutions Private Limited, this was the NCLAT judgment which held that both the amount of the principal, that is the operational debt, plus interest would be included for the purpose of calculation of the 1 crore threshold limit. So with this, we come to an end of the presentation with regards particularly on the Section 9 application and the procedure to be followed for making such application with the judicial judgment and the case laws involved.
Thanks, Jasveen. Ms. Kalpana, can you join as such for 5-10 minutes?
Yes, sir. Yes, madam. Although I'm under meeting, but there my role is complete. So I'm in the meeting.
Okay. Ma'am, you would like to say a few words on the topic?
This is my first occasion when you have invited me. I like the topic very much which you have produced here. With regards to Section 9 of IBC, I was always wondering why the person should apply under Section 9 when he is not getting anything after the plan. But if you see the things, if you see the facts, so most of the cases resolved, most of the cases admitted were by small vendors and suppliers who are stressed because they have not got their receivables. So as they have started opting for IBC under Section 9. Section 9 has become very powerful tool for them, where even judges are taking it the way like they have affected parties, so their cases gets admitted fast. And sometimes these small vendors, they also initiate because they feel that it's very easy to get settlement using IBC. So the Section 9 application they always file so that their amount, which is normally less than 1 crore or around 1 crore, gets resolved at the earliest. Their main intention is to settlement with the company. But Section 9 has recently become very powerful tool for resolution of these small vendors and all those things. If you see, this has become very powerful. 80% of the cases, resolution cases filed by operational creditors are admitted. Out of that, if you see, 19% of all insolvency cases of the operational creditors are closed by way of settlement or some sort of agreement with the corporate debtor. So we consider this Section 9 application is very powerful tool, and you have what has been presented, the various case studies, is really helpful for understanding the Section 9.
Yeah, thank you, madam. Mr. Atul, can you close the session by narrating the topic and as such.
Yeah, thanks, Jaswin, for this wonderful presentations. Probably next time, we'll take the appointment of, Kalpana ji in advance so that, we can have a more sharing of her experience. But thanks once again, Kalpana ji.
I would love to do Atul sir.
Sure. So we run this, webinars, twice in a month. And, in case, anybody missed out this, discussions, we upload this onto our YouTube channel. So please subscribe to our YouTube channel so that, you will get a regular updates, every time. So, yeah, thanks once again. Thanks, participant. And in case if you require something, some important topic to be discussed at this platform, we are always open for it. And Jasveen, thanks, for your wonderful insight, of this topic. So yeah, that was a great, so Mr. Malik has already uploaded you.
Thank you so much, sir.
Yeah, Mr. Malik is also a very senior member of our institute, company secretary, and he's also directors in a couple of listed company. Thank you, Mr. Malik, being a part of it. And
it's always pleasure to attend Mehta's webinar,
Thank you, sir. Thank you. So yeah, probably we'll have somebody said on a session on RERA and IBC. So probably definitely, let's see if we can do something on that also. So thanks all of you, and look forward for more cooperations. And please subscribe to YouTube channel so that you get those alerts on a regular basis. Thank you. Bye-bye. Thank you, Jasveen, once again.
Thanks everyone.
Thank you.
Very good
Kalpana ji.
presentation.
Thank you. Yeah.
Thank
Thanks,
you.
Devang.
Thank you, sir.
Thank you.